Ian Gretsch is a managing attorney in the Public Utility Commission of Texas Legal Division. Ian has been with the PUC since November 2021 and has led or worked on a number of key cases during the time with the agency. Prior to joining the PUC legal team, Ian worked for 7 years as a staff attorney at the Texas Commission on Environmental Quality. His education background includes the George Washington University with a BA in International Affairs and a JD from the University of Texas School of Law. Please welcome Ian Gretsch.
My name is Ian Gretsch. I'm an attorney with PUC, and today I'm going to talk about some updates for the PUC, in particular some rule changes that we've made over the past year, and also an upcoming rule change. When I originally wrote this presentation, it was rule changes, upcoming rule changes plural, but some of these rule changes have since passed, so we only have one new rule that is still not in effect. So the first thing I want to talk about is an update to our STM rules. For those of you who don't know, STMs, it's a sales, transfer, merger, and these are the kind of transactions that a utility will engage in, will apply for if they want to acquire another utility or if they want to merge with that utility. In 2021, the legislature passed this new statute, 133011, which basically allows utilities now to raise rates when they are acquiring another utility. In the past, if a utility acquired another utility, they had to continue using the rates of that utility. And so that kind of discouraged other utilities from taking over utilities that had really low rates, because unless they planned on filing a rate case, which is previously had been the only way you could raise those rates, they weren't really encouraged from taking over systems that had really low rates, just because it would be that high of a hurdle to raise those rates through a rate case. And so what this law did was it allows new rates as long as the rates that are being used are already in force in another system and have been approved by the PUC. Subsection B also forbids us from turning this kind of transaction into a rate case, which is a big concern for utilities because you want to do this on an expedited basis. You don't have to go through that whole rate-making process. So we've been implementing this statute for about 1.5 years, 2 years before we were able to pass these rules. So we learned a few things, and we wanted to clarify a couple of things that had come up while we were implementing this statute. The first being when these rates could go into effect. Problem is with STM transactions, it's kind of a two-phase process, where the first order that you receive is after we've evaluated the entire application and have basically cleared it for financial, managerial, technical capability of providing continuous and adequate service. Once we find out that, or determine that the application is basically good to go, we will then issue an order that allows the transaction to proceed. So that basically allows the two utilities that are merging or switching facilities to close the legal transaction. But they have to come back to the PUC in order to get the actual certificate transferred. And so we are not allowing rates to be raised until that final order comes out when the certificate is actually transferred. So there was some confusion there because of this multi-phase aspect of these applications. And so we just wanted to make it absolutely clear that it isn't until you get that final order that, that you could raise rates. The second clarification we put in is it's just clarifying that this isn't some sort of standalone transaction, that this is part of the STM application that you will see in our rules under 24.239. And this also allows us to incorporate those rules so that if you do want to pursue an application using this rule, it also incorporates all the requirements under our normal STM rules. We also inserted this public interest determination, this kind of catch-all that allows us to look at the transaction as a whole to make sure that it is in the public interest. And in particular, if we do find that the rates are just a little too high, we can claim that it is not in the public interest and basically challenge the application using that. And then finally, phased-in rates. This is something, confusion that came up, an ambiguity I wanted to clear up, but there are certain systems that phase in rates over a number of years just to make it easier on the ratepayers. And so the question came up is if the tariff that the acquiring utility wanted to use is phased in over a number of years, let's say it's in year 3, do you have to use year 3 in that for the new facility? Or can you basically go back to year 1 or choose whatever phase you want? So we litigated a case and got this in front of the commissioners, and they made it clear to us that according to their interpretation of the statute, we could use whatever phase we wanted. So that really gives us a lot of flexibility in trying to find a rate that works for everyone. It helps us settle cases, frankly. In addition to these clarifications, there are some additional items that an applicant will have to submit in addition to the normal requirements under our STM rules. And again, this is born through experience and some directions from the commissioners if we've gotten a couple of these cases in front of them. Mostly they have indicated to us that they kind of want to have an idea of why these new rates, why you want to use these new rates. And so they kind of wanted to look under the hood a little bit. And as a result, we're requiring utilities, applicants to submit financial projections so we can see what the revenue was like before with the old rates and what they expect the revenue to be with the new rates. Similarly, if the utility plans on investing in infrastructure, we want to take a look at that capital improvement plan, and that'll help us figure out where that extra revenue is going to go. If the acquiring utility has a number of different tariffs that they can choose from, we want to know why you chose that tariff as opposed to the other ones. As you can imagine, this is particularly important when the acquiring utility happens to choose the highest rate, why the highest rate as opposed to another rate. The commissioners were also concerned about affiliates, so any kind of relationships that an applicant has with other utilities. They were concerned that there were some shell games that they could play, that passing utilities amongst each other to kind of avoid having to come in for a rate case. So we just want to see all the relationships that exist amongst the utilities so we can ferret out any kind of funny business. We also just kind of want a clear picture of what these new rates are going to look like. So we're requiring applicants to submit a rate schedule that shows the old rates and the new proposed rates. Similarly, a billing comparison, so we kind of get a real-world view of what these new rates are going to look like. So we're asking for a bill comparison for someone that's using 5,000 gallons and someone that's using 10,000 gallons, and what the existing rates for those that kind of consumption looks like in comparison to what the new rates are going to be. We're also requiring documentation about the previous rate case, and this is mostly to prove up that you do have the tariff that you're proposing to use has been, in fact, approved by either the PUC or TCEQ if it's an old tariff. And then finally, we have this catch-all, any information that the PUC requires, case-by-case basis. We also have new additional notice requirements. So these are in addition to the notice requirements in the normal STM application process. But these notice requirements serve two purposes. One is to inform the ratepayers of what the new bills are going to look like. So we're going to require them, or we are requiring them to submit that rate schedule to ratepayers so they can see what the new rates are going to look like. And again, that billing comparison, so they have kind of a real-world view of what their bills should look like. And then finally, number one, as you can see, this how intervention differs from protest rate increases. So at PUC, we do little things a little bit different from TCEQ. We don't have public meetings, so ratepayers really only have two opportunities to participate or to protest these rates. So one is to submit a protest or a comment, and it's exactly what it sounds like, just telling us what you feel about this transaction. And then the other thing is intervene. So if you intervene in a case, you basically become a party to the case. You're expected to participate, to submit testimony, to write, to draft briefs. And so we don't want someone who intended to just comment to find themselves as a party and vice versa. So this kind of standard language we use in rate cases, and because we expect to see a lot more, and we have seen a lot more interest in these transactions as opposed to SDM transactions, since rates are going up, we want people to really fully understand the difference. So the next thing I want to talk about is the repeal of the substantial similarity requirement in the water code. So the repeal of the substantial similarity statute. So in the past, if a utility wanted to consolidate systems under one rate, one of the requirements was that they had to prove that these systems were substantially similar. This is mostly to account for difference in inputs and the cost to operate these systems. So we didn't want high-cost systems to be combined with low-cost systems, but the legislature decided that they want to encourage consolidation, and so they've repealed this. And in the past, this did significantly increase regulatory cost for utilities because this is one additional item they had to prove up, and yet another fight that we could have with us and with the interveners. So the effect of this repeal that went into effect this past session is we can expect to see, and we have seen, a significant increase in consolidations, particularly among larger water and wastewater companies. This just makes their administration of their systems that much easier because they have to deal with some simpler tariffs. So along those lines, we can expect to see larger rate classes. In the past, rate classes were really grouped by geography or by system type. So we would have groundwater systems with groundwater systems, surface water systems with surface water systems. But now you can combine them all. So we're now seeing rate classes that span the entire state of Texas that combine surface water and groundwater systems. But that, by the same token, it does result in simpler tariffs because we were seeing some tariffs that were getting pretty thick with all the different all the different rates for all the different groupings. But inevitably, we will see cross-subsidization between different kinds of systems, in particular between groundwater and surface water systems. So we are currently engaging in a rulemaking. I did say that this was only had one rulemaking. This is technically another one. Although this isn't a new rule, we're just taking out any references to substantial similarity, and has no real effect because the water code has changed, so we're no longer requiring substantial similarity justifications. So the next update I want to talk about is an update to our appellate jurisdiction. So for those of you who don't know, we do not have rate-making authority over all utilities, in particular non-investor-owned utilities. So things like water supply corporations, districts, and in this instance, municipally owned utilities. And so for most of those ratepayers that aren't under our jurisdiction, they do have the right to appeal those rates to the PUC, and we will examine those rates to make sure they're just and reasonable. For MOUs, this appellate right only exists for ratepayers that live outside of the city limits of that MOU, since they can't vote for the people that control the MOU. So they don't really have a check that the people that live inside the city limits do. So accordingly, they have this appellate right exclusive to the people that live outside the city limits. So an issue came up, an ambiguity came up about what happens if these ratepayers that live outside the city are acquired by an MOU, and through that acquisition, their rates go up immediately. The question became, what happened? Can they immediately appeal that rate increase? That wasn't a rate action; it was just the rates went up just through the acquisition, or did they have to wait for a rate action? And we determined, or rather, the legislature determined that those people can immediately appeal those rates. So we have changed the rules to account for that new legislation. There are some exceptions. I'll just go over real quick. If the MOU took over service because that ratepayer asked them to take over service, they can't turn around and appeal those rates. Similarly, if a TCQ or PUC ordered the MOU to take over those ratepayers, we're not going to allow those ratepayers to appeal. And then finally, if the MOU took over those ratepayers through an SDM process, they can't appeal those rates because those ratepayers would be able to intervene or participate in that SDM process. So we don't want to give them a second bite at the apple, basically. So another update wanted to let you all know about is a new update to our submetering forms. Just to let you all know, if you want to submeter at PUC, all you have to do is register and just submit a form. And what we started, an issue that came up is we started noticing that there's these new kind of developments that they're calling horizontal apartments. It's basically where a developer purchases a big lot of land, places a whole bunch of single-family detached homes on that, and then rents them out as though they're apartments. And what these developers have wanted to do is place a master meter and then submeter all those houses. The problem is with the definition of who is allowed to submeter under the water code. And there are only 4 entities that are able to submeter. It's apartment house owners, manufactured homes, multiple use facilities, basically commercial and industrial, or condo managers. And it's the definition of apartment house that's the problem. Apartment house under the water code is defined as 1 or more buildings containing 5 or more dwelling units. So that, by definition, takes out these kind of horizontal apartment developments. And by the way, if they were to build duplexes, triplexes, or fourplexes, not that we know that this exists, the same issue would apply because it has to be 5 or more dwellings in the apartment unit or in the building. So the issue at the PUC is that our forms didn't capture this nuance. We didn't make it readily obvious to registrants what the difference between apartments were. And so we have now inserted language in our form that makes it clear what the difference between a so-called vertical and horizontal apartment. We have also now are requiring utilities to submit an affidavit whereby they are attesting to the fact that the property that they're registering to submeter does in fact meet the definition of apartments under the water code. You may have noticed that sprinkled throughout these slides also references to condos. And by the way, not that we're aware of this happening, but if there's similar development were to happen, a bunch of single-family homes on a big lot, and they happen to be condos, it would be okay. That's because the definition of a condo is a little bit different. All they have to do is basically have common areas under common ownership. So as long as a condo has that, they can basically submeter this similar situation. But so that we didn't find ourselves flat-footed in case there's some kind of new development that we don't foresee, we basically also inserted language in the new forms for a condo registrant to make it clear that they have to qualify as a condo under the Texas Property Code, and then we have a similar affidavit requirement to make sure that the registrant can do that. I now want to talk about an update to our to some of our rules. This is a new rule that was passed last week. In fact, it's effective August 14th. In these situations, the legislature passed a new legislation to update population numbers. So there are a couple of rules that we have sprinkled throughout our rules in the water code that are tied to specific population numbers that they want to capture specific counties. The problem is that those rules were written in the 2010s. The 2020 census came out. Those populations have gone up. So this is basically just an update to capture the same counties. We're just updating population numbers. And then the final thing I want to talk about, and this is our one upcoming rule, and this is, we're going to be implementing a new statute that the legislature passed this past year, and it allows for an expedited SDM process for temporary managers who are want to take over a Class A or Class B utility or system. Even though we haven't passed rules yet, the statute already is doing things that we're implementing, so the process is already expedited as it is. So a couple things that this new statute does. First of all, it waives the public notice requirement, so this really speeds things along because that is probably at least a 2-month process where utilities have to send out notice, have to get notice published, and they have to prove it up to us, and we have to make a recommendation. So that, that takes some time. So waiving that really speeds things along. But as a caveat, if one of these applications by a temporary manager, Class A, B utility, as part of an SDM, if they add another element to their application, so let's say they want to add some area or subtract some area, those notice requirements for that additional kind of application will still apply. So this really only waives the STM notice requirements. The other thing this does is it basically takes care of our FMT analysis. So as I mentioned earlier, the core of our analysis when we're evaluating these STM applications is we want to make sure people have the new owners or the new operators have the financial, managerial, and technical capability of providing continuous and adequate service. So what this new statute does is the very fact that a temporary manager has been appointed as a temporary manager is, by definition, meets that FDM requirement. So that, again, really speeds along our analysis because that requirement is taken care of. However, the legislature did not want these to be rubber stamp kind of applications. So there is this public interest determination that allows us to challenge an application in case, let's say, a temporary manager has been operating the system poorly. Once it's acquired the system, we can challenge that application using this. And then finally, it's kind of a way to encourage temporary managers to not only take over systems, but to invest in these systems, which I know has been a problem in the past, considering they're temporary. The ledge has added this language that provides that any used and useful invested capital and any O&M expenses that are just and reasonable can be booked as a regulatory asset, and that asset would be recoverable in the next comprehensive rate case. All right. Well, I appreciate y'all's time.